Cameras turned off, the campaign has died, but the work we started, it never subsided. From the desert floor to the mountain height, we're shining the torch, we're bringing the light. 17 counties under one big sky. We're watching the records, we're asking them why. Oh, W4Nevada, the people's own desk, putting the truth to the ultimate test. For the school boards, the cities, the local town hall, we're showing up, brother, we're answering the call. From the receipts to the findings, we lay it all down. Accountability in every Nevada town. If the shadows are growing and you need some sun, bring it to us, now the healing's begun. Speak plainly, speak loud, let the truth be heard. We're keeping our promise, we're keeping our word. W4Nevada.com, you know where to go. Call or text that number, let the power flow. 702-381-4295. Nevada for Nevadans, we're still alive. Power back to the people, power back to the people.
Good morning and welcome back to W4Nevada Live. I'm Matt Winterhawk and you are joining us. Continuing coverage, Day 16, Coyote Springs Investment LLC versus the state of Nevada. The case number is A as in Alpha, 20820-384-B as in boy. We are set to reconvene at 10 a.m. Stephen Shell will be returning to the stand. Thank you so much for tuning in today. I hope you all had a fantastic week. I know that we've been on fire, literally, all across the northern section of Nevada, and lightning strikes in dry areas are continuing to cause even more and or erupt even more situations and or incidents that, frankly, our people are tired. Our first responders are exhausted. For weeks, the Bug, the Stallion, the Hawk Fire, the Oxley Fire, name a fire, S1, the Via. It just continues to go on and on and on, just fire after fire. And meanwhile, while these fires are raging on, there's an event that Northern Nevada typically depends on for income. And they prepare heavily for burners, right? We understand that the Burning Man Festival is also synced up within the same weekend. Now, I've seen many different videos and accounts of people that are attending the Burn Festival, and their camps are destroyed. They spent days, 3, 4, 5 days building camps, and everything they built up has been destroyed due to the wind. So I would assume that it might be a rough burn this year. Now, I want people out there, burners, I have no hate or animosity towards you. But the situation happens to be where everything landed at the same exact time, didn't it? We've got fires raging on, and you could say, yeah, that happens all the time. But we're talking about thousands of Northern Nevadans that were displaced. And if you look at the availability of hotel rooms across that area without having to go 60 miles out, and many of my Northern Nevadans and fellow Nevadans were stranded without their vehicles because of the situation and how rapidly they had to evacuate. So it's nothing against you personally. I just hope that you have the heart, forethought, and care for your consideration of fellow human being, as you state, as burners are so caring and considerate You would make sure those resources are available for those who have been affected by fires inside of our state of Nevada, our beautiful state, 110,000 square miles that everyone loves to come enjoy. And what happens in Vegas stays in Vegas, right? And also Nevada. See, that's the problem. So all I'm asking is for a bit of humility, a bit of serious focus on what you leave behind and what resources you are utilizing in a time of need when it's critical for Northern Nevadans during this situation. That's all I'm asking for. Not asking for miracles, not asking for anything unreasonable. I catch a lot of hate, but the difference is I'm always going to put my fellow Nevadans, my fellow Americans, my fellow humans first. Your feelings, your emotional, you bought concert tickets, or you bought a venue ticket, or you set up a vacation. Many people have many things that fall through every day in terms of plans. So if that happens to occur, there's no reason for you to also take that animus and or aggression out towards people who want to protect Nevadans first, and or people who are requiring the resources, hotel rooms, restaurants. And it would seem that it gets overlooked. They're like, oh, what does it matter? We're bringing the money in. It's fantastic that you bring the money in. Northern Nevada needs it. Rural counties need it. I would rather they get the money from people that go out and party at the playa and do a great job in supporting an area that doesn't get much support, Gerlach, in those areas, than have data centers moving in, handing $1 million, walking away with 20 years of destruction. So please don't get it misconstrued and or confused as to what my priority is here and or how I view burners. I think that people that are artistic, creative, are amazing people. But I also believe that at the end of the day, they have hearts too. So they're going to understand exactly where I was coming from with that article, and that's why it's an opinion piece. So without further ado, let's see how close we are. We got 2 minutes. I did just see there was something else going on inside the room there. I wanted to make sure we weren't privy to any information that we are not
2020
legally allowed
June
to be involved in.
24th.
Which looks
I had
like
a call
they're
with Max Counter.
still having something going on there inside of the court case. So we got our note-taking queued up, ready to take on Day 16, Coyote Springs LLC versus State of Nevada. Stephen Shell returning to the stand. We are on Week 5, ladies and gentlemen. I know 5 times 4 would be like at the end 20, but we're already at Day 6. Like, the weeks don't make sense. That's because we're starting on Day Thursday. You know, I saw, I want to say that I saw the plaintiff's attorney, Mr. Hernquist, and I saw a attorney representative from Poldenac, Sylvester and Poldenac, for the state of Nevada on Monday morning, and they did a motion. Now, I'm not quite sure what the motion was. I probably should figure that out. It might have something to actually do with what the situation is today. 10 a.m., I was like, oh, I was up. I was ready at 9 a.m. I had everything queued. We were ready to go, and then I get in here. I was like, 10? And I was exhausted because I was burning the midnight oil, as they say, creating video games and updating nonprofit associations and working on my children's school lessons for Day Thursday as a homeschooling father. There are many pieces that go into what W4Nevada is. It's just like you. I'm a citizen. I'm a Nevadan. I'm an American constitutionalist at the end of the day. I care a great deal about the foundation of why we're here, which is why I take it incredibly serious to make sure that we're educating and getting people to civically engage and utilize their power in governing the bodies that are elected or appointed, or nonprofits, or anyone that touches our money, our funds, our resources as the people, we, the people, and the public. It's my job. It's what I'm here to do. At least that's how I feel. So how are you this morning? Make sure you say hi down in the comments, share it out, tweet it, post, comment, do whatever it is that people do. And we'll be here waiting. Let's see here. I'm going to go as soon as it hits there. We're at 10. Like, I bet you anything, Mr. Honorable Mark Denton will be like, "Come on, I got court.
Submitted
things to do."
supposedly kosher
Finishing up
version of that with the court separately. I know Mr. Kellner has called this a clerical error, but it would not be possible to be a clerical
this morning. Just waiting for these cases here early this morning to wrap up so we can move into our day. What did we have? Fires, and more fires. All night fires, all day fires. I feel like the whole world is on fire. If you were to pull up like Perimeter Map or some fire assistance app, you would realize very quickly that everything is on fire. I'm not quite sure as to why. It just is. Dry lightning, that's a thing. Yeah, let's see here. Where's our update for the evening? We had 0. So we had a, if you go over to W4Nevada while we're waiting for our actual court case to start here, excuse me. So you got $0 tax bill, Nye County's grid lines votes Tuesdays, 59 road dedications, a construction damage deal, and $0 tax bill. Nye County's grid lines vote is Tuesday. Next Era linked transmission. By the way, if you look up Next Era, there are donations to the current sitting government inside of the state there in Nye County from Next Era. Does not publish road agreements, repair, security, cost terms, and portal showed $95.39 bill on a separate grid lines parcel before commissioners were asked to correct it to 0. That got zeroed out, man. We don't want to pay no taxes, dang it. The grid lines parcel is located at 6340 East Crazy Horse Street in Pahrump. The APN or associated parcel number is 037-261-08. I'm not quite sure how and or how much of that you can see. So this is a very major thing that's going on. It affects Nye County. So if you are a Nye County Nevadan, you'd probably want to take a look at that article. We've got that going on. We've got, I dropped this one last night. You've got 68 different test boring holes that are coming in from Greenlink. Now, I post the instructions, links, every piece that you need in there in order to protest, to get the proper information full from BLM. I've listed CFRs that respond and give you the correct instructions on how to respond and legalese. You've got PUCN dockets that you can look up. I've got references inside of there as well. NV Energy's presentation to White Pine County. So if you want to take a look at that article, we've got that going this morning. We've got, I mean, there was a lot happening yesterday. Solar, there was a $5,000 airport gift. And then we had Silver Springs Water District, a $9.42 million sewer plan. And commissioners out there in Lyon County are associated with that. And this $5,000 Ampere, AMPYR, it's a solar project that is donating directly to the commission. $5,000, woohoo! White Pine County. Now, I will say that I specifically heard them say that they wanted to go over the legal, but the problem was they had already accepted the funds. I don't know. We'll follow up with that more as that story develops. And then we were talking about the wildfires. More than 20 wildfires across the Northwest started and striking from where? Well, as I was told, from lightning in the dry area. 35 new fires, 9 new large incidents, and 17 uncontained large fires across the Great Basin geographic area. More than 20 lightning starts near Winnemucca. So if you're up there in Humboldt County and or Pershing areas, you'll be watching out for Juniper Ridge Fire, the Sombrero Fire. Got 1,200 acres on Juniper Ridge Fire, 10% containment. Last time I looked at the numbers, Sombrero Fire was 11,000 acres and 20% contained. And Sombrero's approximately, so dozens of it where Water Canyon Recreation Area is closed. So 11 and approximately 12,500 acres total. The McConnell Fire about 3 miles east of Orvada. So if you go north out of Winnemucca, you start heading towards that lithium plant up there, and you want to go take a look at that horrible atrocity. Anyways, let's head on back over. We should have just enough time to get back in here. Let's see.
Thank you. Can I respond, Your Honor?
So we're still wrapping case. 10 a.m.
Okay, thank
We're
you.
starting late.
All right. to complete recess. And,
all right, they're going to take a quick recess. Fantastic. We're just in time.
All right.
All righty. We'll be getting ready for this case. I'm going to mute myself and fade into the background, ladies and gentlemen. Thank you so much for tuning in today. You are watching W4Nevada Live. I'm Matt Winterhawk. 17 counties. We the people. We the press. You're watching W4Nevada Live.
Vegas shine, that's the stage. But baby, we're more than the glow. From Carson City to the back roads, we got that old state soul. Churchill ride, clock keep moving. Douglas wind through the pines. Elko sky, Esmeralda dreaming. Every Hear that name roll slow, like a river through the sand. One state, one home, in every county, man. We're Nevada, baby, Nevada all the way. We're Nevada, baby, from the night to the day. Carson City.
Yeah, there's Howard.
Good morning, Mr. Levitt on Zoom. Can you please identify yourself? Mr. Levitt, can you hear me? Hello, those of you on Zoom, can you hear me in the courtroom, any of you?
Yeah, I can hear you.
No.
Yes, I can hear you. Just so you're aware, I can hear you.
Thank you so much for answering.
Absolutely. And good morning to all of you.
Good morning. Mr. Levitt, can you hear me?
I just emailed him to say he identified himself.
Is he
We do have a James Levitt, so I just
Lodett?
think so. Okay. But I just emailed him to tell him to identify himself.
Mr. Levitt, can you hear us in the courtroom?
We could just remove him, couldn't we?
Yeah, you want me to?
Yeah, until he comes back on and identifies himself. I think that's the fastest thing to do.
Levitt's an attorney with Howard and Howard. I don't know what interest he has.
Yeah, I'm assuming that's him, but I was just emailing him to make sure it's not someone else because he has nothing to do with the case.
He said he's just observing today. Just chatted us.
What is it?
Okay.
He said he's just observing.
I'll go see.
We're good, Jim?
Is that your associate?
It's the name.
Are we good, Jim? Not yet? No. Oh, now
All right. From 13 pound section on the marker and driver.
Good morning, please be seated.
Morning.
All right, we're resuming in Coyote Springs versus State of Nevada. Appearances of counsel, please identify parties and party representatives who are present today.
Good morning, Your Honor. Mark Hutchison on behalf of Coyote Springs Investments, LLC, and related plaintiff entities. And my co-counsel with me today is Carl Nelson and Todd Kennedy. And then the general counsel of Coyote Springs Investment, LLC, and related entities, Amelia Cargill, is with us in the courtroom as well, Your Honor.
Good morning.
Good morning, our Jeffrey Sylvester and Matthew Sylvester Blending on behalf of the state of Nevada.
All right, our counsel and parties ready to proceed.
Yes, Your Honor.
We are, Your Honor.
All right,
But it's for the record, Mr. Whittemore has returned to the stand.
all right, very well. Do you realize that you're still under oath, sir?
Yes, sir.
All right.
Good morning, Mr. Whittemore.
Good morning.
I am certain that this is an extraordinary inconvenience on your time and your family's time, but your testimony is important both to the state of Nevada and I'm certain CSI as well. So I think collectively we'd like to thank you for returning. Mr. Whittemore, I'm gonna try to move as quickly as possible so we don't impose on your time. I'm going to try to speak as slowly as possible. We can see if I can't mesh those two things together. Okay.
Thank you.
You ready to proceed?
Yes.
Okay. Ms. Cargill, testified for a number of days on both direct and cross examination. And part of the testimony, not specifically, but generally related to her role as general counsel for Coyote Springs. And I just want to sort of probe your memory with respect to her retention and her job description and duties as you understood it during the time period that you were a member and manager of Coyote Springs. Okay.
Okay.
My understanding from her testimony is that she was first an associate and then a partner at Lionel Sawyer and Collins. Does that comport with your recollection?
Yes, sir.
I understand that Lionel Sawyer and Collins had differing practice groups within the firm. Is that correct?
Correct.
Do you recall what practice group Ms. Cargill was in when she first was employed and then as she became a partner through that process?
The commercial department.
I think she said primarily, and tell me if this comports with your understanding, she was in the transactional section or
Sure. You can call it the transaction group, commercial department.
To your knowledge, did she have any experience in environmental resources or water rights during the time period that she was employed in that practice group?
Don't recall any.
There came a time when you left Lionel Sawyer and Collins. And by the way, when did you leave the firm?
Probably left in 2011.
Okay. So you were still employed by Lionel Sawyer and Collins during the time period that you formed and acquired the property in this case?
Yes, sir.
Did there come a time in roughly the 2006 time period where CSI sought to employ Ms. Cargill?
That's generally the time frame.
Do you recall the circumstances by which she became employed by Coyote Springs?
My brother David made a recommendation that Amelia was somebody who he felt could handle the types of transactions that were contemplated by our ongoing operations in Southern Nevada.
And when you say types of transactions, do you have something in mind generally?
I think the role of a good general counsel is to advise management as to the potential pitfalls, business practices, the types of counsel that is delivered almost on a daily basis by someone in her position that would be, you better look at this. My advice is to structure a transaction this way. You have to be careful about following to ensure the company's objectives are reached. So it's a role that's traditionally identified depending upon the size of the company. You could have advisory roles with respect to human resource issues. You could have advisory roles with respect to real estate transactions, litigation, those sorts of things. And again, general counsel being the descriptive it's general. It's not a specific sort of cubbyhole like you would in a traditional practice in a large firm. You're required to have a breadth of at least an understanding of certain transactions. I thought Amelia did a good job in terms of advising us when we were in developing the property at the time.
Developing the property at the time, by the time, my recollection of Ms. Cargill's testimony was she was employed by CSI in the May 2006 time period.
That sounds correct.
Okay. And as it relates to the development of the property, as I recall your testimony and direct examination, by 2006, you had already entered into a development agreement with Clark County. That was approximately 2002. You recall
That's
that?
correct.
And you had begun the Habitat Resource Conservation Plan, at least with respect to Clark County at that time?
That's correct.
You had the specific plan approved as a major project in the 2002 time period?
That's also correct.
Okay. So she wouldn't have had any involvement with respect to the development plans and efforts prior to her arrival in May of 2006?
Other than as a potential timekeeper on tasks that she would have done at Lionel Sawyer and Collins based upon an assignment from either the client or another timekeeper at Lionel Sawyer.
Your, sorry?
A partner, timekeeper, most generally another partner.
In addition to the development agreement and the conservation plan, there were other significant development and work done by CSI and you prior to 2006. You recall that generally?
Yes, of course.
You acquired the water rights certainly in the 1998 time period from Nevada Power.
Correct.
You had participated in the, you had filed the applications for 108,000 acre feet of water.
That's also true.
You attended the 1169 hearings to consider those pending applications, correct?
True.
You testified in those hearings.
Yes.
As did Mr. Savely, correct?
Correct.
And as I recall your testimony, Mr. Savely was an environmental resource expert.
I considered him as such because of his depth of practical experience before Carl came to the firm. And he was someone I relied on at Lionel Sawyer and Collins to provide advice with respect to a wide variety of natural resource issues.
Would that have included water rights during the time period you were at Lionel Sawyer and Collins?
Water rights, mineral rights, those types of issues, yes.
So going back to Ms. Cargill's role when she was first employed, I accept your definition of general counsel. Was she making any business decisions on behalf of CSI?
No.
Was she consulted or advised with respect to the water rights and permits that CSI had acquired?
If there had been a pending issue and required a meeting of our general sort of management council, she would have definitely been involved in the discussions. I don't recall any specific instance where Amelia said, hey, you have to do A, B, C, D, or E to either me or Brad or one of the Dirks. Either Rob or Gary. I don't know, again, as I indicated in my prior testimony, I don't know the exact time that Gary left. But again, Amelia would have been included as a senior sort of employee with an obvious skill set. She would have been included in multiple meetings, sort of a round table.
As it relates to improvements that were going to be made by CSI and either by you or your other managers or members, was that part of her role to weigh in on the nature, extent, and scope of improvements?
Objection with regard to ambiguity on improvements.
Okay. I'll try again. When I say improvements, I mean either physical or other improvements that were necessary to move forward the master plan community.
Certainly, someone with Amelia's background would have been able to provide advice if we had a question about a particular contract. I'm confident that the officials in Las Vegas, officers in Las Vegas, would have used Amelia as a sounding board on any particular thing. But again, we're in the middle of attempting to get the golf course, party transactions, those sorts of things in a state where we could move forward with the development. So there were multiple opportunities for legal advice with respect to those types of issues.
Legal advice, I certainly appreciate that. But with respect to withdraw the question, she wasn't an officer or director or member or manager of the entity beyond the role as general counsel.
No, and it was a lot of things that general counsel do ministerial, in the sense that what they do is sign documents that require signatures, review, approved by count. You see it in a governmental role, Your Honor, where certain documents are approved as to form, and you've seen it where, again, counsel has to weigh in and say yes or no with respect to the types of things that the client is going to sign.
As it relates to water rights, the applications, well, the question. I think you testified under examination, perhaps on cross, that in the legislative scheme, from time to time, you need to seek extensions to establish beneficial use.
Correct.
Or actually even apply for permits with respect to new water rights. Is that also fair?
Fair.
Were those decisions made by you and or Mr. Sabley?
Would have been made by me based upon what Carl's advice was. As his honor knows, you have tickle systems within the practice of law that create obligations for activities to take place within certain timeframes. And so we held a very robust system to ensure that appropriate filings would be made and extensions would have been included in that.
And the actual determinations about when and how to file those extensions of time or to submit applications, for instance, to establish beneficial use, that would have been determined by you and or Mr. Sabley. Is that fair?
I think that's fair. Carl would have had a more robust role in that, even though he was, based in Reno, because that's where the bulk of my time was.
He too served in capacity as counsel, didn't he?
Yes.
He wasn't a member, officer, or manager of the entities?
No, I don't think we included Carl or Amelia, any of our lawyers, as managers or members. We did have some of our other business staff take on those roles on temporary basis within certain institutions that were created. I recall specifically Jim Harris, Brad Malmer.
Is it fair to characterize Ms. Cargill's role and what she provided was essentially legal advice
Yes.
and transactional?
Yes.
The party agreements, we've seen them, I think, briefly in your direct and cross. The first one was entered into in 2004. Does that comport with your recollection?
Yes.
And then it was amended in 2005. You recall that?
Generally.
And that 2005 amendment essentially became the operative document, though it too had been amended. Is that fair?
Multiple times.
I think 9.
It sounds correct.
Okay. And so the original party agreement and the amended agreement that became the operative agreement was negotiated and documented before Ms. Cargill joined in May of 2006.
Yes, with the proviso, I don't recall any role that Amelia may have had at Lionel Sawyer in the development of those documents.
Fair. Okay. And as it relates to the acquisition of the Tuffy Ranch property, that too occurred in, I think, the December 2004 time period is when it was actually recorded. Does that support your recollection?
Yes, we had done, as I indicated in my testimony, I don't know whether it was direct or cross. My direction to our management staff was to bring as many transactions as possible with respect to the acquisition of additional water for the project.
One of them being Tuffy Ranch. Fair to say that because unless she had some timekeeping role at LSC, she wouldn't have been involved in negotiating or acquiring the Tuffy Ranch property.
She had no role in the negotiation at all.
Fair to say she didn't have any role in the negotiation of the party agreements?
None that I recall.
Other than perhaps on a transactional basis for any amendments that may have occurred after her employment in May of 2006.
Correct.
Welcome. Blind to myself, Mr. Whitmer. Here we go. Lindsay, can I have states admitted exhibit 3301, please?
What's the number?
3301. Can you enlarge that for Mr. Whittemore, please, and for me? Mr. Whittemore, I'm not sure we spoke about this, or at least you didn't speak about it on direct, but this is a amended application for permission to change point of diversion, manner of use, and place of use of the public waters of the state of Nevada. And it's titled number 70430. If you turn to the third page at 003, Lindsay. It looks like it was approved on the 22nd day of April 2004. Do you read that okay, Mr. Whittemore?
Yes, Hugh Ritchie approved the request pursuant to a application that we had made to the state engineer.
And if, Lindsay, if you go back to page 001, please. Looks like it was filed, date of file in September of 2003. And the, you can see at number 1, it's the source of the water is the underground. Item number 3 reflects that the water is to be used for municipal and domestic.
Correct.
And then item number 4 indicates that the water had been permitted for industrial. And so reflecting on that document and your testimony, you recall that the original permitted application that's been referred to as the 46777 permit was issued to Nevada Power or Nevada Energy?
That's correct. And in our prior testimony, we had indicated and discussed that use was limited to industrial.
It was. And if you recall, sir, the point of diversion for that water that NV Energy was seeking and obtained was from Basin 210 or the Coyote Springs Value, but the place of use was going to be in a different basin to support the Harry Allen power plant.
That's correct.
Okay. And so from the issuance of the 46777 through the date of this approval, that the permitted or manner of use remained industrial?
Correct. Until this application had been approved.
So as we see the date being the 2004 date, all of the work in improving the property that we discussed the term improvement with respect to habitat conservation, to the extent that completed, the development agreements, all the architectural and engineering services that might have been employed, all of that occurred before the manner of use had been changed from industrial to municipal. Fair?
Fair.
Okay. And there came upon a time when it became necessary, you had progressed far enough in the process to change the manner of use to the municipal use, correct?
Correct.
Do you recall, sir, that the application that was granted permitted the water to be used both in Clark County and Lincoln County?
Correct.
And that was the intent in establishing or developing the master plan community to use that water on both sides of the county line.
That's correct. We did not want to limit it to just Clark County.
Right. So you could, to the extent water was available, develop the Lincoln County side as well, if available.
As I previously testified, we wanted an integrated water delivery system.
Right. When you say an integrated water delivery system, perhaps I didn't hear that on the direct. What do you mean by that, sir?
It means that, and I think I did a little bit, we didn't want to have a subdivision that had a street that crossed county lines to not have a water system that was fully developed as a result of, again, just a line in the sand. You wanted the water pipes, you wanted the wells, you wanted the pump stations, you wanted the storage systems to be able to serve zones. And where that took place was irrelevant with respect to just simply Lincoln County versus Clark County. If, again, a map showed a subdivision or a major area that required water service, you didn't want to have duplicative systems in place. What you wanted to do was have it integrated, just like a utility.
There were 2 separate GIDs formed, were there not?
Correct.
Was it the intent at some point to have those GIDs, the general improvement districts, have the ability to share essentially the same water?
That was always the intent.
And you'd have to build the infrastructure to allow that sharing to occur?
Correct.
As we look down a little bit further on that document, it talks about item number 11, the description of proposed work. And it says drilled well, pump and meter, piping, electrical power services, and distribution system. Do you know, sir, what the purpose of item 11 is from an application standpoint?
Under Nevada water law, you are required with respect to getting from a permit to a certificate stage, you have to show what your proposed work. It's sort of an archaic statutory term, Your Honor, that in the practice before the state engineer, you just simply describe, I'm going to drill a well. It's going to have the following depth. It will have the following pipe size, casing size, those sorts of things. And so what you're trying to do is give the state engineer an idea that you know what you're doing with respect to withdrawing water for what your proposed use is. So the works describe, this is what we're going to do. The use is, this is how we're going to do it, and this is where we're going to do it, and who's going to ultimately get the benefit from it.
And then you have to estimate the total cost of the works as you have identified in the previous paragraph.
Yes.
And that's, in this case, 100,000.
Yes.
And then when you file an application to extend the time period to establish beneficial use, you have to demonstrate you're making a good faith effort to complete the works that are the subject of the application and permit.
You have to not only demonstrate that, but you have to show that the phasing that you have described is actually met.
Okay. So when you say phasing, what do you mean, sir?
I mean, if you said, I want an extension of time for 2 years because I'm going to do A, and that gets you to a point certain, you would then file another extension and say, I would like to do B, and you'd get time frame for that. This $100,000 and drill the well, the pump and the motor, the piping, the electric power service and distribution system. The estimate of the works is probably low. The time that's needed is, the construction works is reasonable at 2 years, and the beneficial use at 10 years is very reasonable.
Okay. But the amount in section 12 provides notice to the state engineer about how much money you intend to expend as it relates to the works that are identified in the application.
In this case, it's the minimum amount that we would have put in.
You certainly had additional costs and expenses that you would incur in developing the master plan community, but that's different than what the described works are.
Yes, again, to a degree, but that $100,000 number that is described there, I think is very, very conservative. I think we probably spent more than that on the quote described works of 11, but I don't think you go into the state engineer and say you're going to spend $5 million. When you overestimate those things, the administrative agencies don't like it. What you want to do is be conservative, describe what you think is appropriate. But again, as I indicated in my testimony, I think the $100,000 is a little bit low, but I think everything else is probably pretty accurate.
But it's low with respect to what is identified as to the description.
Just the phases, yes.
Right. And then on an application to extend the time, if you recall, sir, without stating the form, it has the amount of money expended to date, as of that date, to essentially complete the work that's described as a project there.
Yeah.
And then how much more you intend to expend going forward, again, related to the project or scope of work set forth in the application.
It's fair.
Lindsay, may I have states admitted exhibit 3299, please? Oh. 3299.
Okay.
And it's, sir, if you or Liz, if you would turn to, I think, the second page of that document. Let's say 70429 at the top, sir.
Okay. Yes, I see it.
Oh.
Thank you.
This is the maybe back up foundational. You recall that 46777 was essentially split into one or more different permit numbers?
Yes, because the total was 5,000 and you'll recall there were the A water rights and B water rights. And so we had to file two separate applications to change the point of diversion, manner of use, place of use with respect to the two different types of water.
We'll just move through this one quickly. It seems to be very similar to the one we looked at 70430.
Correct, other than the distinction being disclosing to the state engineer that the water rights at issue have been split into A rights versus B rights.
And these applications and the permit that was granted allowed that water to be used in both Clark County and Lincoln County. You recall that?
I do.
The description of the proposed work seems to be, I think, relatively the same as 70430.
I would have expected as much.
Again, the estimated cost is $100,000, and the time period to construct the works was estimated to be 2 years. And did you say it was a fair estimate of time for that work?
It was.
If we can turn to the next page, 003, and we'll go back and look at 70430 in a moment. But the top of it in the remarks section indicates that it's going to be used for the municipal and domestic purposes, and all the balance of that language that's included. And then on the approval of the state engineer, these are the conditions upon which the state engineer approved the application to change the manner of use and place of use.
Correct. The engineer imposes in that section a description of the types of conditions that he or she wants to impose upon the applicant to ensure that the orders in the prior proceedings are managed and held sort of your feet to the fire to do so.
Okay. And then just briefly, in that second full paragraph, it also it relates to and cites permit 4677 and essentially imposes on this permit those same requirements that were in that original permit. Do you agree with that, sir?
Generally, I think that, again, Mr. Ritchie, state engineer at the time, wanted to ensure that the conditions of the underlying permit are carried forward into the new numbers. And so what happens, Your Honor, is when you go look at a particular permit or application, unless you go back to the base permit, right, sometimes you'll get confused as to what the underlying conditions are. And this is a way for the state engineer to ensure that those conditions are carried forward.
And it actually states that it's granted under permit 4677 is issued subject to the terms and conditions imposed in that permit. You see that in the first full sentence or first full paragraph?
Yes.
Okay. It also has by the way, the recall that the base permit was conditioned upon monitoring program.
Correct.
And that was actually part of ruling 4542 that approved 4677.
Yes, and those conditions were accepted by CSI as the, in effect, subsequent holder of the base right.
Right. You took an assignment of the monitoring obligations and responsibilities from NV Energy that held the permit initially and assumed those obligations.
That's correct, with the following correction at the time it was Nevada Power.
Okay.
Darn it.
Again, also has the same language with respect to the right to regulate the use of the water.
Correct.
Okay. And then the fourth full paragraph, it begins a monitoring program. You can highlight that, Lindsay, please. Now, at this time in 2004, 1169 has been issued. That's in March of 2002. Do you recall that generally?
Generally, yes.
And this provision incorporates the requirements of 1169. Do you agree with that?
Yes, sir.
And then again, the last full paragraph, it discusses the monitoring, the annual review of the monitoring requirements, which is, I think, the same language we've seen in 4542 and 4677.
I believe that the state engineer wanted to be consistent in all the documentation regarding the use of water in Coyote Springs.
Linda, can we just go back to 3301 just for a moment to confirm that that same approval language appears in that approved application to change the manner of use. We won't spend time on it. Just it's on the second page. 002, Lindsay, please. There we go. Just take a look at that language and see if it generally is consistent with the conditional approval of 70429.
I believe so.
In 2004, you were beginning your negotiations or discussions with parties. Is that comport with your recollection generally?
Yes, sir.
Okay. By the way, how long does that negotiation process last with party?
Probably 90 to 120 days, maybe a little bit longer. Multiple meetings with a lawyer by the name of Steve Levy, who was counsel to Party at the time. And so we'd have meetings in Party's or Weyerhaeuser's corporate offices in Los Angeles. Multiple discussions with Cliff Andrews and John Lash and others in Las Vegas to go through what you would generally characterize as deal points. So long process.
Extensive due diligence period?
Significant.
I'm sorry, extensive due diligence.
It's correct.
You understand the term due diligence? As
I do.
Okay. Lindsay, can I have States Admitted Exhibit 3310, please? And Mr. Whittemore, I'll represent to you, and I'm happy to show it to you, that the party agreement is entered as of May of 2004. I want you to take a look at this correspondence of October 26, 2004, and tell me first, sir, if you can generally identify it, and take your time if you'd like to ask Lindsay to peruse the document so you're comfortable with it.
Can we go to the signature page? I believe this is a letter I wrote to Tom, and we previously, I think I previously identified that it was under my signature. Can we go back to the bottom of the letter? The last page of the letter, not the last page of the document.
Try 0017, Lindsay.
Yes. So that's, again, that is a letter, Your Honor, that I previously identified that recites in very significant detail the efforts which we have made and to create comfort with then manager Tom Riley as to the efforts that Coyote Springs has made with respect to the project. You'll see the people that were copied on that included Rob Dirk, Greg Borgell, Doug Carriger, our person that was helping me with respect to Lincoln County, Kermit McMillan, and Carl Saley.
And just for the court's edification, can you explain to him who Mr. Riley is as the county manager and what his role is, if you know?
Sure. Tom Riley had the function of being the chief executive administrative officer of Clark County at the time. His role was to direct staff to engage with all manner of issues and to present those issues as appropriate to the Clark County Board of County Commissioners, which would have required their approval on any number of items that we were requesting.
But he was the county manager of Clark County, correct?
That's correct.
There's a significant number of references to Lincoln County. And why, sir, if you would explain to the court why you're referencing the development on the Lincoln County portion as well?
Well, we had to properly present what was going to happen with Clark County as it related to the size of the development over the entire property. This was not just a Clark County project. This was a multi-county project which required 2 GIDs because you had 2 different county structures, and we were fully disclosing to Clark County what we were doing on Lincoln County and vice versa. The Lincoln County people knew exactly what was happening in Clark County because it was on that basis that they were willing to help us adopt a new portion of the Lincoln County Code having to do with development agreements and engaging with us to present what we thought we would be able to do in Lincoln County.
Were you attempting to have the two counties coordinate one with the other as you move forward to developing the master plan community?
I think that's fair.
The at page 003, Lindsay, please. And if you just highlight, Lindsay, the second bullet point all the way through the fourth bullet point. Just take a moment, sir, to read that to yourself and just lift your eyes, and when you're done, I'll ask you a couple of questions.
Okay.
So it appears that there's a discussion as I review your letter with respect to the amount of water that CSI owns and what it hopes to or believes it can control on a go-forward basis. Is that a fair characterization of the letter?
Well, there's clearly a reference of what we own, what we believe we control, which means what we believe others are obligated to deliver to us. And I was trying to provide to Clark County comfort that there was sufficient water to provide continuous permanent service for homes that would have been developed on the Clark County and Lincoln County side, businesses, everything. It was a way of me representing to Clark County that we were in the process of ensuring that we were not going to run out of water.
And certainly at this time you wrote this letter, you believed that was the amount of water owned or controlled or perhaps could be acquired by CSI?
And controlled, the answer is yes, subject to the proviso of control, meaning that we would be the ultimate beneficiary of the work of others to either get that to the Lincoln County side or the Clark County side in terms of having a, quote, utility that would then provide that service to Coyote Springs generally, Coyote Springs being the 42,000 acre project.
Right. You may not own the water provided by a purveyor, but it would be an obligation hypothetically for that purveyor to provide the water.
Sure. And again, we had we were under no illusion that we would not have to transfer water that we owned to the benefit of a GID so that they could deliver water to third-party purchasers, either residents, commercial entities, golf courses,
okay,
hotels.
The I understand the 108,000 acre feet. Those are the applications we've talked about.
Sure.
For 1169.
Mm-hmm.
The last full sentence of that first bullet point says CSI has also finalized or is in the final stages of finalizing additional land and water purchases within the region over 37,500 acre feet of certificated water rights and over 15,000 acres of land. Do you recall sitting here today what that related to, what property and water that related to?
Tuffy Ranch.
And then the next bullet point, it says CSI has entered into an agreement with a private local water company with the intent of providing wholesale water to Coyote Springs General Improvement District for potable distribution to the community. And what are you referring to there, sir?
Relationships and agreements with Vidler Water Company.
Was that what has been referred to in this case as the Cane Springs water?
Cane Springs plus any other water that Vidler was in the process of attempting to acquire.
And can you just give us a little more background in that concept of not just the Cane Springs water, but other water that they acquire Vidler?
Vidler's business plan was to and is to acquire water rights in the Intermountain West, provide wholesale water delivery service to multiple users, utilities, and or governmental agencies to provide water service to ultimate users. My sense was at the time that Vidler was had a good idea as to what they thought they might be able to acquire. Therefore, I felt comfortable that we could make the representation that we were controlling this 87,000 acre feet of water, because based upon what the pending or an idea of what the pending unit count might be, I always felt that we would need somewhere between 40 and 80,000 acre feet of water on a continuous permanent basis for the build out of the project 25, 30 years down the road.
The project being defined as the 42,000 acres?
Coyote Springs generally, in my mind, always included Lincoln County. So when I say Coyote Springs, Your Honor, I mean the Coyote Springs project being 42,000.
And for the court's edification, you perhaps just gave me the description, but just explain to the court what Vidler Water Company is, if you haven't just already included that in your last answer.
I think I did. Vidler is a regional entity which engages in purchase or development of water rights in I know Arizona, Nevada, potentially Utah. They're now owned by D.R. Horton, and so which is a major company that develops residential projects. And the business plan was the same, which was to develop water for the benefit of users within a particular territory. And in this case, they had a strong relationship with Lincoln County and were in partnership with Lincoln County to develop resource so that Lincoln County could develop resource necessary to expand the proposed Coyote Springs project within Lincoln County.
And in the paragraph it references, they could, if I can read it correctly, there's the potential for up to 50,000 acre feet of banked water rights. And what does it mean, banked water rights, sir?
Banked water rights, the concept of banking water rights is where, in my use of this term, it's where a developer goes to a city, county, or other municipal agency and says, please hold this water for the benefit of the development. You control it, you own it, but you're obligated to put it into the utility that's ultimately going to provide service. So banked means exactly that, Your Honor. What you're doing is converting the agency involved into sort of a trust or an escrow to let them hold the water for the benefit of the community.
Thank you. You indicated that there was a relationship between Vidler and Lincoln County. Did Lincoln County, to your knowledge, also have water rights separate and apart from what Vidler might acquire?
My understanding was that they did.
Did you ever have discussions with Lincoln County about perhaps utilizing some of its water for the development of the community?
I thought that was always what was going to happen.
I mean, separate and apart from Vidler. I'm sorry.
Yes, on a regional basis, what we were trying to do was to get as many people committed to delivering water to particular locations, either by distribution or wells or otherwise, to facilitate the development of the entire project.
Conceptually, you indicated that the intent was to share water between those two GIDs. If Lincoln County had put water into the GID, would it be anticipated that water would also be used for the Clark County side as well?
Yes, we understood that the GIDs would have to have cooperative agreements between two entities to provide seamless service to customers throughout the project.
As of 2004, did you, on behalf of CSI, believe you were in a good position with respect to water?
Yes, sir.
Linda, can I have 3315? There we go. So this is a copy of the grant bargain and sale deed that's recorded. You can see faintly at the top, it looks like December 29th, 2004.
That's correct. That's the deed between the deed from Carey Holt Farms to Tuffy Ranch Properties LLC, our entity acquiring the property, which has previously been described as the Tuffy Ranch Properties.
And Lindsay, if you go to 009, please, it's just a declaration of value page. It's going to be tough to read, but it indicates that the total sales price, it looks to be, is that 33 million roughly?
That's correct.
Okay. On direct examination, one of the last questions that I think council asked you in your response was that this Tuffy Ranch property was the most significant acquisition that CSI made other than acquiring the Aerojet property. Do you recall that testimony?
Yes.
And could you explain to the court why it was so significant?
We were buying a ranch of extraordinary value with certificated water rights at a very significant level that I felt would be capable of being used in the proposed Southern Nevada Water Authority pipeline. And so it was the premier piece of property that Southern Nevada Water Authority or its associated or affiliated entities had not yet acquired. And we were able to make a deal with Carey to acquire it.
Beat him to the punch, SNWA, and you acquired it?
Yes, I think that Southern Nevada Water Authority would have acquired it ultimately. In my mind, I think, yes, I think the only other people doing what we were doing were smaller players.
Just as an aside, was there an allocation in the deed with respect to the land versus the water?
I don't know that. I'd have to go back to other documents. I don't know that it's broken out.
Was CSI buying it for the water?
Oh, both. I think the land itself has very significant is a very significant resource. We grew potatoes there, alfalfa, very significant protein levels, Your Honor, in the alfalfa, specialized equipment to convert the alfalfa into types of product that could be delivered in Japan. Again, protein levels in agricultural terms, you want things that have high value, and this was certainly one of the products. I know that everybody in our organization recalls that we bought potatoes from Tuffy Ranch and gave them away at Thanksgiving to people. Woman's name was Evelyn Mount, Your Honor, who provided significant resources to underserved people in the Reno Sparks area, and we were glad to support that effort by bringing in potatoes and putting them in bags and giving them away. So great resource.
You indicated that CSI purchased, or Tuffy Ranch purchased certificated water rights. And just for the court's edification, is that more beneficial than simply permitted rights?
Your Honor, as we've discussed, the certificated right is ultimately the gold standard. It's what you get at the conclusion of putting all the works in, using the water, putting it to beneficial use, providing all that information to the state engineer and ultimately getting certificated water rights.
And this was the water that was acquired that was intended to be put into the S&WA pipeline for the use in both Clark County and Lincoln County?
Yes, sir.
If I haven't, I would proffer proposed exhibit 3315.
I don't have any objection to this, Your Honor.
Thank you, counsel.
It's already in from July 29th.
Cindy, can I go to 3302, please? And this is the option agreement that we discussed a little while ago, and I'll get you to the signature page. I can orient you in time, but the as of date is May of 2004. Do you see that in the first paragraph?
Yes, sir. That's consistent with my recollection prior to me delivering or saying that party was our partner to Tom Riley in October.
One of the things that you said in the examination last time you were here is that the business plan at the closing of the Aerojet transaction was to entitle the property and then to sell it in part to a production home builder. We call that generally?
Yes, sir.
Objection, incomplete recitation of the witness's testimony.
Say that again.
Objection, incomplete statement of the witness's prior testimony. So it misconstrues the testimony, Your Honor.
Follow up on it.
Ms. Whittemore, if I ever attempt to or inadvertently misstate your testimony, just tell me. To make you do a better job. Do you remember the question and your answer?
Yes, I mean, as we discussed in my prior testimony, we wanted to use Wingfield Springs as a model to further develop our Coyote Springs project, which was to entitle it, show people that we had the resources necessary to develop it, and to find someone who would come in and be a production builder who had the same consistent values that we did in terms of the scale, same ideas as to what we wanted the community to look like.
And that was the same thing you did in Wingfield, was to sell it off to essentially guest builder or production home builders, at least in part, reserving for yourself commercial or recreational.
That's generally correct, as I indicated in my testimony, other than when the Sino brothers came in, Tom and Albert, they did some building at Wingfield after I left in Foothills.
But by the time Albert Sino Jr. comes in, the party agreement had already been entered into, because it comes in 2007 time period. Recall?
That's correct.
Okay. And at that point, pursuant to these various party agreements, CSI has already granted an option to party to be the exclusive production home builder on the properties. Recall that generally?
That's correct.
Okay. So to the extent that one or both of the Sinos wanted to build homes, they could be building custom homes, perhaps.
Correct, and or participating in the development of the resort core. Ultimately, you have to talk about multifamily. You talk about whether you're intending to allow single family attached versus rental product, those sorts of things. So there are all sorts of different types of variations.
But by the time party comes to the table, most of the entitlement work has been done on the Clark County side, correct?
That's correct.
And I think that there were some pending development agreements in the Lincoln County side, generally.
Generally correct.
As I recall your testimony, sir, at least in your deposition, that you and your then partner essentially came out of pocket or made capital contribution for the entitlement cost from closing forward. Is that forward with your recollection?
Yes, we either borrowed it or put it in.
When you say you borrowed it to be from a financial institution?
Well, we had credit lines throughout the Wingfield and Coyote Springs projects, and whether we use those resources to make improvements or to do other things, ultimately it's an obligation of the partners. And in our case, you want to treat them as loans so that you can get your capital back out.
My recollection is that you had estimated that entitlement cost to be between $5 and $10 million. Does that comport with your recollection?
I think so. I recall that in my deposition. As I sit here today, you know, I might have missed it by a couple of million, 5 million on either side, Your Honor. It's an estimate.
One of the other things that you wanted the partner, like a party or a different national home builder, was to install what you refer to as backbone infrastructure. Do you recall that generally?
Yes, sir.
And can you just generally describe for the court what you meant when you indicated you wanted the potential builder to put in the backbone infrastructure?
Well, as I previously testified to, what we wanted was someone to be, and I use the reference on other occasions with respect to other things, shoulder to shoulder with us to come in and be responsible for the types of improvements which got the development to the point where we could begin the actual construction of those types of production homes at the same time that the backbone infrastructure would be used for the maintenance of the golf course, other types of uses, nursery. We had the potential for mineral operations. So all of those backbone infrastructure things, including the development of the wells and all the major pipelines within the roadways and the development of the roadways and the entry monumentation, would all be considered to be sort of a backbone expense.
I think your testimony was that you and your partner didn't have the capital at that time to put in the backbone infrastructure, and you were looking to a national home builder to do that.
When I said didn't have the capital, I think probably looking back, what I meant was I didn't want us to have to spend money that we didn't have to spend. What you want to do is utilize other resources to have other people at risk, which is why you want someone like Part E to come in and put their muscle into it and their money.
You wanted to sell it on a net basis as opposed to acting as the bank.
Correct.
At the time that you first entered into the agreement with Part E, is it your best recollection that the property was essentially raw dirt?
Essentially.
And as of that date, were you essentially close to zero out of pocket?
Well, I think, as I indicated, the transaction was structured in a variety of ways. I don't know from a tax basis whether we would say that we were zeroed out or what the tax returns would have shown as a net investment. But I would say that if you take snapshots at any particular point in time, we were in a, as I indicated in my deposition and testimony, we were in a really good cost position, because in effect what we had done was use the sale of the water to reduce our out-of-pocket expenses associated with the acquisition of the property.
Okay. The going back to the due diligence with respect to Part E, open book with those folks, give them whatever they want to see?
Absolutely.
As it relates to water and water availability, would you have provided to them essentially the permits that you owned for their review consideration?
Had to.
Would you have provided them with copies of the orders or rulings by the state engineer relating to those permits?
Yes.
Would you have provided to Part E the same information that you had provided to the Clark County manager, Tom Riley, as it relates to what you believed you had the ability from a water perspective?
Yes, and I think we covered this in the option agreements about us. My shorthand way of referencing this, Your Honor, is to quote, stay ahead of the game, that what we wanted to do was to always be 5 years ahead of where they were going to be. So if they were going to build 1,000 units, then we needed for the following rolling 5-year period, that the 5th year out, you had to get water for the next 1,000. And if they did 500, the second year, in the 7th year, you needed to get 500, water for 500. So what you were doing was always staying ahead of the game.
Yeah, and there's a provision, I'll be happy to show it to you, that you had to make a good faith effort to acquire additional water for what's defined as the entire site.
That's exactly what I'm talking about.
But as it relates to the water, you provided all of the information that you had with respect to what CSI intended to utilize to support its master plan community.
Yes, sir.
That would have included the Tuffy Ranch property.
We would have advised them, number one, party was aware of the Southern Nevada Water Authority pipeline project. We would have advised them that we acquired this water with anticipation that ultimately, if needed, we would use that water for development of the project. We were hoping still that the 108,000 acre feet of permits was going to be good, that we were going to get some significant portion of that.
Yeah, I mean, it's the what you had been advised by folks like Terry Katzer and Pete Moros is that there was this significant of water underlaying the Coyote Springs property.
In the carbonate aquifer, that's correct.
You certainly had a belief that that water was available, correct?
That's why we did what we did.
You didn't guarantee it.
No,
You didn't guarantee it to Part E, correct?
I couldn't.
Why is that?
You'd be making representations as to a function that was outside your control.
In fact, you made no representations and warranties as to the availability or guarantee of water, fair?
We could guarantee that which we knew that were sort of in our pocket. But as we previously discussed, the state engineer maintains the ability to make changes with respect to what you think you have.
Certainly, that would have been something you would have disclosed to Part E during the due diligence time period.
I don't think it was asked because I think the people reviewing these documents understood that to be the case. I don't recall specific discussions about it, Your Honor.
You did, though, essentially represent you make a good faith effort.
Oh, absolutely. It was good faith.
And did you in fact make a good faith effort, sir?
Yes.
Can I go to 0055, Lindsay, please? This is an exhibit to the option agreement we just looked at, and it appears to be that what I refer to as the takedown schedule. Is that something that you would refer to it as?
Yes, it was a very significant exhibit to the agreement.
Can you explain to the court why that's a significant exhibit?
Your Honor, this is an option payment schedule that describes the amount of money that party would pay to Coyote Springs based upon the year of particular takedown, showing that we negotiated a price per acre beginning at $40,000 for each potential acre, which was described in the agreement as being somewhere around $30,000 acres. If you start at the 40,000 number, you end up at a very significant amount per acre based upon the length of time or the year in which the option is exercised. What we did was, rather than put in a CPI, Your Honor, we negotiated a yearly rate. And I don't know what the actual CPI number is, Your Honor, I could give a calculation and say, well, it went from 40 to 42 to 45, et cetera. But if you get down to the bottom, Your Honor, you'll see in year 40 that the price per acre is $726,000 per acre. And obviously there's an incentive for us and Part E to try to get paid earlier in time. If you take a look at the year 20, you're only talking about 118,000. And you know, it's a significant increase. It's just like insurance on a mortgage. You don't want to have to necessarily continue to pay insurance to the full 30 years of your life of your mortgage.
You recall that this option agreement was recorded both in Clark County and Lincoln County?
It was.
Do you recall?
Or a memorandum thereof.
You recall that there was a requirement that the parties agree, execute, and record CC&Rs?
Yes, for the protection of the development, one of the significant things that was negotiated was a requirement that each party act in accordance with covenants and representations that each party made to the other.
But what's the purpose of a CC&R?
Covenant conditions and restrictions, Your Honor, is something that you're aware of that runs with the land, that binds all subsequent purchasers to act in a certain way with respect to the property. Things such as height restrictions can be, you name it. It could be a lot of different ways to enforce certain obligations.
Is the intent to assure some uniformity with respect to the development?
The specific purpose is to ensure that, again, what happens and why Part E wanted it to be recorded in both Lincoln and Clark, because they didn't want the Clark County side to be their project, and then all of a sudden trailers are immediately adjacent to your $600,000 home.
And that's because they had the option on the Lincoln County portion as well.
They did.
The purchase price, you can go to it if you need a refresher. It was 66 million. I can turn to that.
I recall that was the first takedown.
Okay. And then, Lindsay, if we can go to admitted exhibit 3306, please. This is Amendment 2 to the 2004 agreement. And if you turn to the second page of that document 002, it reflects an increased purchase price to $84 million.
That's correct.
And can you recall why that increase took place?
We were adding additional property and giving them an option to acquire additional things that they wanted.
Lindsay, can I have you turn to 004, please? And item number 13, if you could highlight that, please. There's a reference to a development declaration. Do you know what that is, sir?
Yes. Within the Coyote Springs development, Your Honor, we wanted, again, a very precise list of the types of homes and or facilities that would be built within the project. And so these builder declarations would establish things like color palettes, the types of product homes, the types of elevations, what you would do with respect to water use, the amount of grass that could be grown, those types of things, Your Honor. So again, very precise level of negotiation as to what the obligations of each party are with respect to the development. If you take a look at the exhibit, it goes into great detail.
I'm going to show you that in a bit. In that same document, Lindsay, if you could go to 0006.
What's indulgence? Mr. Chesler, which exhibit is this that you were mentioning? Is this 3306 you said?
Yes.
Yes.
Okay, I just.
Sure.
Let you know, that's.
Move for its admission. Proper proposal is 3306.
Is it in?
No.
Oh, no objection. I can't imagine this isn't in.
Yes, admitted.
I have no objection.
Admitted.
Thank you. And so we were, I think, moving our way to 3306006.
Yes.
And just take a look at that document or that paragraph and tell me what the purpose of it was, sir.
18,
19.
19. Okay. Okay.
And do you recall what the purpose of that provision was, sir?
Yes, it's paragraph provides that there are certain improvements called the commercial improvements, which is the fine term, and they're going to be required to be certain costs are going to be required to be shared, and those are called the jointly financed improvements. And so if you went to the Exhibit 6, you would see again a list of all of the things that the parties thought were appropriate to be jointly financed. And again, as I previously indicated, we just simply couldn't take the money and run. Council, we had to put the money back into the property. And that's one of the things, this list of jointly financed improvements.
Okay. Lindsay, can I have page 3330, please? So this is Master Declaration of Covenants, Conditions, and Restrictions. It appears to be recorded March 31st, 2005. And just tell me generally if those are the CCNRs that we have been discussing required to have been filed.
That's correct. This is the face page of the CCNRs for, I believe this is, and if we can turn to a page and make sure that this is Clark County, I'm sure that they're set.
I think it's Lincoln County.
Yeah.
At the top, can you see the recordation stamp?
That's what I'm trying to determine, whether it's Lincoln County or, but I could tell if we went to an area or a description of the property, but in any event, Lincoln County. It's Lincoln County.
Yeah,
Yeah,
I see the
I can see it now.
You see, yeah.
Yes, that's what I was looking
Okay.
for.
And Linda, can you go to 0010, please? And Mr. Whittemore, in item F, and Lindsay, if you can highlight the language that begins declarant intends. There you go, and all the way through the bottom of the paragraph, please.
Yes,
Says the declarant intends the LC development agreement, that's Lincoln County Development Agreement,
that's correct.
and the related documents governing development in Lincoln County to be consistent with the provisions of the CC Development Agreement, that's Clark County,
That's correct.
and related documents governing development in Clark County to provide a seamless community across county lines. Can you advise the court or explain to the court what you intended with respect to that provision, a seamless community across county lines?
I didn't recall that my use of the word seamless was in the CCNRs, but it's exactly what I previously suggested, Your Honor, which is I wanted Lincoln County and Clark County that if you were driving along the street, you wouldn't know that you crossed into from a quote, largest county to a smallest county sort of experience. What you wanted was an experience internally that you didn't know that you were moving from one county to the other. It was seamless. You crossed over the line and didn't see the difference.
Okay. I haven't proffered 3330. I'd move for its admission.
No objection, Your Honor.
Sorting in.
Thank you. Can I go to 3331, Lindsay, please? And this is looks like the Clark County recordation of the same CCNRs. Do you see that?
They're the CCNRs for the Coyote Springs Master Plan Community. I'm confident that the internal references Carl would have made a distinction between Clark County and Lincoln County based upon the internal references. But other than that, they would have been very similar. Yes.
We'll go to 0011, please, Lindsay. We'll just see if that language in paragraph F mirrors the same language we looked at a moment ago. We see that same language of seamless community across county lines.
Yes, I do.
As an aside, the multi-party or multi-species habitat conservation plan, was that required on both the Clark County and Lincoln County sites, or?
As I recall, it was required under probably the act and other agreements that we would have made with relevant federal agencies.
When you say the act, are you referring to the
Nevada, Florida Land Exchange Act, or Florida, Nevada? I don't know. I can't recall the correct way.
I've seen it 100 times and I'm not sure I remember either. Declarations filed. Okay. Okay. May I approach Madam Clerk?
Yes.
Sorry. Yes, oh, is this an animal?
Yeah. Anybody with you?
Yes.
We spoke a little bit ago, Mr. Whittemore, about the builder declaration that we referenced in the option agreement.
Yes, this would have been something that Carl would have drafted.
Is it Carl Sablin?
Yes.
I didn't know he was also a transactional lawyer. Was he also a transactional guy?
Very good. Yes. He was in that department at Lionel Sawyer and Collins, and I used, in fact, if I've referenced Carl as just being a natural resource lawyer, that's unfair to Carl. He's a very good transaction lawyer, and he was in the transaction or commercial department, however you want to describe that department within Lionel Sawyer. And this is a document which he drafted because you can see it on the footer of the document itself. The CDS is Carl D. Sabley.
So just explain to the court what this is, and then we'll just look at a couple of provisions.
Your Honor, these are the builder declarations that Party and CSI entered into to, again, require that the development covered under the option agreement looks a certain way, acts a certain way, and results in a community of a certain way.
Lindsay, would you bring that down? I think we still have the CC numbers up. There we go. Lindsay, do you have 4056? Thank you, man. Huh? Yeah. There we go. Now we can all see what you can see. And the first recital, it states that CSI owns or has owned and conveyed that certain real property situated in Clark and Lincoln County, as described, commonly known as the Coyote Springs Master Plan Community. And then the next provision indicates, relates to the undeveloped portions. At At 404, Lindsay? Get word back. Well, I apologize, I got the wrong number. Oh. No, I've twisted you up there, Mr. Wrong.
On the screen, do we jump from 403 to 406?
Oh, there we go. 4056. I'm sorry, Mr. Whittemore and Lindsay, if you can go to 4056, just 002, please.
Okay.
This identifies the covered property to mean all of Coyote Springs and the benefited property to relate to all of Coyote Springs.
That's correct. Coyote Springs being the all of the property. It is a defined term, and Carl has an internal reference that the covered property is Coyote Springs, but then Coyote Springs is a defined term, which means that it's all the real property situated in Clark and Lincoln County as described on Exhibit A to the document. And I don't have an Exhibit A to the document yet. Let me see. Yes, I see it. And that's a legal description of Coyote Springs being the property both in Lincoln and Clark County beginning at 0046.
Oh, thank you. If Lindsay, go to 0041, please.
Okay.
We're waiting for Lindsay to catch up.
Okay.
You see item 22.6, Lindsay? And that indicates that these covenants are going to run with the land, right?
Yes.
And sir, you left, I think you testified about it like before, but I can't remember if it was 2011 or 12, or do you recall?
I left Lionel Sawyer and Collins in 11, I believe, and I don't know when my last day was with the Coyote Springs entities or the Wingfield entities.
Whatever that date is, to the best of your knowledge, did the CCNRs and the declaration, did they continue to remain a covenant on those lands or burden those lands both in Clark County and Lincoln County?
Yes, they would have. They could only be terminated by agreement between both parties, and I've never seen such a document.
And party was still in the transaction, if you will, of the project.
When I left, that's correct.
Yeah, I've moved for submission, Your Honor.
No objection, Your Honor.
Admitted, that's 4056, correct?
Yes, Your Honor. Lindsay, can I have 3367, please? And the front page of that, Mr. Whittemore, is titled Amendment Number 1 to amended and restated option agreement for the purchase of real property. And it amends the restated option agreement, and it's entered into as of July 28th, 2006. I just want you to take a look at, sir, for a moment. 33670014. And you had previously indicated that there was an agreement to have jointly financed improvements by between CSI and Party. Does this reflect the agreement to the best of your recollection as to how those improvements were going to be jointly financed?
Yes.
Okay.
What it did was describe what portion CSI was going to pay versus Party. What was, if you look at the last big paragraph, it was 50-50. The second paragraph was 30-70. And the initial paragraph was 12.5, 87.5, Your Honor.
Do you have a recollection as to how those allocations came to be?
Negotiated between myself and John Lash and Cliff Andrews, our team. When I say me, I mean Coyote Springs. It would have included Brad Mommer, Rob Dirk, and they would have had multiple consultants like we did that would have described what the potential cost was and why the allocation needed to be the way that it was.
I want you to just focus on the second set of allocations.
Yes.
And just talk briefly about the off-site detention basin. Did you understand that was a requirement by the Clark County Regional Flood Control District to have a detention basin?
Both. Whether it was required by government or whether it was required by good engineering planning, you don't want your development to be overrun with flood issues. And so you need to have places to store water, move water. Very significant efforts were made by Coyote Springs to ensure the nature of the development would work.
Thank you. Let's shift away from the party agreements for a little bit and talk about the what I refer to as the capacity agreement. Do you understand what that agreement is generally?
Yes. Well, it depends on which capacity agreement you.
Let me get there. Lindsay, can I have 3347, please? Take a look. There's a series of 3 or 4 documents included within that. The first one is an assignment and assumption agreement. And then attached to that are a number of exhibits. Just familiarize yourself with the document first.
Yes, this, I mean, I understand what the document is, Counsel.
I'm sorry?
I understand what the document
Okay,
is.
so the first page is the assignment and assumption agreement.
Correct.
Okay, and just generally explain to the court what this document purports to do.
What this is doing is ensuring to Lincoln County that it will be responsible for all of the assumed obligations, which are described in the attachments to this agreement. That basically what happens is Lincoln County is trying to avoid a situation where there would be a burden on Lincoln County rather than the burden on the beneficiary, which is Coyote Springs. And so what we're doing is saying to the county, whatever is required with respect to the assumed obligations, Coyote Springs is going to guarantee those obligations.
And if we look at 0004, this is Exhibit A to the assignment and assumption agreement, and it's styled General Capacity Agreement for Participation in SNWA Groundwater Project.
That's correct.
So this was the Lincoln County Water District essentially reserving capacity within the SNWA pipeline?
Correct.
And there was going to be certainly a cost associated with that. And if we look at Exhibit B, which is 0011, this appears to be the guarantee of CSI guaranteeing the obligations that Lincoln County had assumed pursuant to the capacity agreement.
Yes, can you pull up the footer on that, the CDS? I think this is
It
the
is.
one that Carl,
CDS.
okay. Okay. So, Carl would have drafted this for our review and approval, Your Honor, to guarantee the payment of what we previously described as our obligation to the county.
Essentially, it's the agreement by CSI to pay for the costs associated with bringing that pipeline down, correct?
Capacity within the pipeline.
Capacity in the pipeline.
Yes.
But there was a prorated cost associated with it.
Yes.
Do you recall, generally speaking, what that prorated cost was?
No.
Was that separate, this agreement separate and apart from an improvement cost associated with the pipeline itself?
No, I don't think that was a breakdown there. I think that what we were saying is that we want to have, we need to have the ability to put water in a pipeline that you're bringing down. If you bring it down, we want to have the right to piggyback on the work that you're doing, and we'll pay our pro rata share associated with what those costs might be. But we didn't want to have to do an individualized pipeline. You could certainly, but this was our way of guaranteeing that there was some sort of shared costs, Your Honor.
And you've anticipated that potential capacity agreement, at least since the time you purchased the Aerojet property. You were going to find some way to join into that.
As I previously testified, we were aware of the Southern Nevada Water Authority pipeline project generally prior to purchasing the Aerojet property, because I wanted to make sure that we had belts and suspenders with respect to the utilization of our property for its anticipated use.
And that's sort of because you knew and understood that the permitted rights could be regulated. And if so, it could frustrate your business purpose.
Objection, this construes prior testimony. Lacks foundation.
I wanted, as I previously testified, to get, it's not funny, Your Honor, but the way I described this was more. You needed to have a commitment to the process of acquiring additional water rights to make your business purpose flourish. And this was a way of me anticipating that, to say it's good business practice not to let the last bus pass you by and you're sitting there at the bus stop and not hopping on the bus. I wanted to make sure that we had a seat on the bus.
Thank you. Lindsay, please bring up 3349. And this is a water supply agreement. And it's signed by you. It looks like the effective date is February 2006. Seems to correlate with the other agreements we've looked at.
Yes, what we were trying to do there was to say Tuffy Ranch is going to be committed to helping Coyote Springs investment, even though they're affiliated entities. Your Honor, you need to have a document that describes what Tuffy Ranch's obligations are to Coyote Springs, because they are separate entities, and to put it in writing.
And this providing water to both the Lincoln County and Clark County portions of the property?
My best recollection is that this was coming to Lincoln County initially, and that we hoped that by delivering water to the Lincoln County side, it would flow down because of the transmissivity to the benefit of the Clark County portion, and whether you delivered the water by distribution systems from wells or storage facilities located on the Lincoln County side, it would accrue generally to the benefit of the entire project.
Thank you, sir. I want to shift now to just a little bit of discussion with respect to the GID and the ordinance that formed the GID. And that occurred in the 2006 time period, recall?
Yes, generally.
Do you recall that there was a hearing in connection with the attempt to establish a GID before Clark County?
Yes.
You recall attending that?
Yes.
And I think in attendance with you, I believe it was Mr. Andrews, I think.
I believe so. Cliff Andrews.
And can you just describe for the court what the purpose of the hearing was and why you were in attendance and testified?
It was a necessary prerequisite to continuing to have parties' commitment to the project. That what you needed was the creation of something other than Coyote Springs that was going to be conducted by professionals for the benefit of the community, i.e. a general improvement district.
Lindsay, can I have proposed exhibit 3377, please? And so this is a transcript of that 2006 hearing. And if we can go to 3377-0009. You can see that you're there, and so too is Cliff Andrews.
Other than the misspelling of Cliff, yes, it reflects what I just indicated.
And Cliff was with Party, correct?
Party Homes. Mm-hmm.
And you recall you and or Mr. Andrews advising Clark County that CSI was assuming all of the risk with respect to delivering water?
Yes, that's what we said.
And was that what you understood, at least at that time, that it was the developer's risk to provide that water?
In this context, what we're saying to the county is that we're going to assume the risk to get you what you need so that you can make the promises that you need to make to Party Homes, the ultimate beneficiary of the agreement, and its customers are purchasers of homes.
Thank you. Your Honor, I would move to admit proposed exhibit 3377.
I have no objection, Your Honor.
Admitted.
All right, so the GID is formed in the 2006 time period, and then I want to shift your attention to what's called or known as a multi-party agreement. And Lindsay, if I can have states 3382, please. And tell me, sir, if you can identify the document. I'm happy to.
Of course, I'm generally aware of it. I need to see who signed it, whether it was me or one of our, to further identify it, Your Honor, I just need to see what the signature pages are. And
I can take you to 0032, Lindsay.
yes.
And this is where, as I understand, you tell me if you have a different understanding of the agreement, is the multi-party agreement selects Las Vegas Valley Water District as the general manager of the GID.
That's my understanding.
And do you know why it is that CSI chose Las Vegas Valley Water District to be the general manager of the GID?
Because it was consistent with the regional approach to the development of water within Clark County. We wanted the best, and they were the best, and we wanted it to be integrated so that we wouldn't, it wouldn't be perceived, Your Honor, as a one-off master plan community, that it would be, you know, just like everything else in Clark County.
Was the GID intended to be the water purveyor for CSI?
Yes.
And they were going to act, that the district was going to act as the manager of the water purveyor.
Correct.
And to the extent that, let me have foundation. Generally speaking, you understand that before a subdivision map can be approved in the state of Nevada, that there's a requirement to provide a will serve letter to the state engineer?
Objection, foundation, calls for legal conclusion.
Sustained.
Legal conclusion.
Sure. You've been a developer in Nevada, correct?
Correct.
You were a developer on CSI, correct?
Correct.
Do you have some understanding with respect to what's required regarding the commitment by the state engineer to provide water to a subdivision?
Yes, the statute requires the state engineer to approve a subdivision map. And the way that they would approve it is if they were convinced that there was water sufficient for that particular map. As we described in my testimony earlier, Your Honor, municipalities, agencies require different amounts of water. The agreements to provide it are much different throughout the state. And again, this would have been a step in the direction of getting a process in place to get subdivision maps approved.
At paragraph, if we go to 0012, Lindsay, please. You see the commitment process paragraph?
Okay.
Just read that to yourself and tell me when you're done.
Yep.
Is this, do you understand this provision to require the certification to the state engineer to the extent that there is water available to support the subdivision?
Yes, it's the sort of the fail-safe mechanism, Your Honor, that I previously described that says if there's unused water above a certain amount, we're going to be able to do X, Y, and Z with respect to the subdivision map process. But if it falls below that, then we have to, as the developer, establish to Coyote Springs GID that there's going to be sufficient water transmitted to it so that it can continue to provide sufficient water, or show to the manager that there's sufficient water so that they can then certify to the state engineer, who can then stamp the approval.
Thank you.
Would this be a good place?
It would be, sir.
Good time to recess. Let's recess for lunch and reconvene at 1:15. Thank you, Art.
Thank you. That's all right.
Here we go. Thank you for tuning in. We are going to a lunch recess. We'll be back at 1:15 p.m. I believe that is the time that we will be back at. If not, look for us before then. In the meantime, I'm going to put up the Be Right Back sign, as we will be right back. We'll put on some music, and please feel free to text, share, put this out there. We have visibility issues tremendously, so thank you again for watching W4Nevada live. My name is Matt Winterhawk. Have a great day.
Nevada, can we talk for a minute? Not politics, not noise, just home. W4Nevada live, Nevadans talking to Nevadans. I heard a mother down in Clark say something ain't right at the school today. I heard a washer say the water's thin, and nobody tells us where the money went. Out and now they've been raising their hands, asking who keeps selling off the land. Stories watching all those power lines, wondering who pays when the bill comes due this time. We don't need a polished speech, we just need a place to speak. Bring your heart, bring your name, bring the paper with the date. Can we talk Nevada? Can we tell the truth tonight. From the valleys to the mountains, bring what's hidden to the light. Call it in, text it in, let your county say its name. 17 voices singing, but the heartbeat is the same. Can we talk Nevada? This is home, this is us. Real voices, real receipts, real follow through, real trust. Carson City, I can hear you too. Churchill's got a story coming through. Douglas knows what pressure feels like. Elko's still working under big sky nights. Esmeralda, don't you disappear. Eureka, your voice belongs right here. Humboldt, Lincoln Line, every small town still gotta shine. Lion, Mineral, Persian too, White Pine, we ain't forgetting you. 17 counties, one lone road. Everybody carrying a different load. If it's water, let's talk about it. If it's school, let's talk about it. If it's budgets, let's talk about it. If it's buried, bring it out. If it's power, let's talk about it. If it's land, let's talk about it. If it's public, don't hide it. Nevada, we're done being quiet. Can we talk Nevada? Can we tell the truth tonight? From the valleys to the mountains, bring what's hidden to the light. Call it in, text it in, let your county say its name. 17 voices singing, but the heartbeat is the same. Can we talk Nevada? This is home, this is us. Real voices, real receipts, real follow through, real trust. Say what you heard, say what you know, say what they try to keep down low. Bring that email, bring that file, bring that agenda they buried a while. Bring that picture, bring that name, bring that question they tried to shame. Rumors are leads, receipts are proof, and we follow the trail till we find the truth. Cause it's county, we can talk, Washoe County. We can talk, Lake County. We can talk, Narrow County. We can talk, Carson City. We can talk, Chuckin County. We can talk, Douglas County. We can talk, Lyon County. We can talk, Story County. We can talk, Humboldt County. We can talk, Riga County. We can talk, Riga County. We can talk, Esmeralda County. One Nevada dream. Can we talk Nevada? Can we tell the truth tonight? From the valleys to the mountains, bring what's hidden to the light. Call it in, text it in, let your county say its name. 17 voices singing, but the heartbeat is the same. Can we talk Nevada? This is home, this is us. Real voices, real receipts, real follow through, real trust. Nevada, pick up the phone. This is your county, this is your home. W4Nevada live. Nevadans, talk to Nevadans. Real voices, real receipts, real voices. Fresh white box, clean lace tuck. Bad luck if I step too tough. Tile floor, I move light. One wrong crease and it ain't right. Corner store, I slide through. Old heads not like they knew. I keep it smooth, I keep it low. Every step on tiptoe. Hold it back, don't rush now. Hear that snap, move hush now. Tip, 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 tiptoe down the street. So my Jordans don't crease. Tiptoe down the street, yeah, easy on me. Tiptoe down the street, so my Jordans don't crease. Tiptoe down the street, they all know the routine. Tip, 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 tiptoe down the street. Tip, 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 tiptoe down the street. Curve too high, I pivot slow, no scuffs on the toe. Let it go. Pavement cracks, I pick my line. Keep that pair in a perfect shine. Man on the block say, how you glide? I say, man, I don't waste no stride. New day fit, old school pride. Won't let one bang kill my vibe. Don't rush now. Hear that snap? Move hush now. Tip, 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 tiptoe down the street. So my Jordans don't crease. Tiptoe down the street, yeah, easy on me. Tiptoe down the street, so my Jordans don't crease. Tiptoe down the street, they all know the routine. Tip, 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 tiptoe down the street. Tip, 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 tiptoe down the street. One wrong step, that's a heartbreak. So I glide like a clean break. Slow motion when I cross that line. Fresh pair, I make 'em mine. Tip, 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 tiptoe down the street, so my Jordans don't crease. Tiptoe down the street, yeah, easy on me. Tiptoe down the street, so my Jordans don't crease. Tiptoe down the street, they all know the routine. Tip, 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 tiptoe down the street. Tip, 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 tiptoe down the street. Yeah. Yeah. I came up where the blocks don't sleep. Hands on the wheel, eyes on the seams. Then ice walking, still I don't freeze. Hungry in the rain with the weight on me. Used to move that product just to eat. Now I move like truth with a cold little creed. Every scar told me what I need. Every loss turned heat to a tighter squeeze. I ball like Jordan, but I hit like Tyson. Talk big, then the room go silent. When I live that life, better know the timing. Pressure on my back, I've been built for climbing. Pock in the frame, keep fighting. Keep a pace when the night keep biting. Big impact when I step in the cipher. Sky in the limit, it's a line I'm writing. Cast the doubt out, cast it on me. I was made in the fire, now it don't cost me. Talk that talk, then watch how they watch me. I don't fall for the fear, I don't stop, see. Keep fighting, keep fighting.
You're watching W4Nevada Live. I'm Matt Winterhawk, and we'll be back after this lunch.